everybody. Thanks very much for coming. The leaders have put on a great spread here insofar as, and hopefully we can help you here with any legal questions or the process in relation to getting the tenants out or getting them to pay monies on time if they're not. As Alison kindly introduced me and said, I am a solicitor at Coleman's. I've been there for over 3 years, and I deal with all disputes, but particularly landlord and tenant disputes that we have that arise out of tenancy agreements. Property law, it relates to various things, including residential, commercial, dilapidations and things like that. But today we're focusing on residential because obviously you all are landlords and rent your properties out to the different tenants, and therefore what we try and do is to help you in order to make sure that your landlords and themselves are happy and confident that they are being managed and you are able to get the expertise that you require in order to be able to get possession of your property if you need it. So the main thing is, when we act for predominantly landlords, there is the odd occasion that we do work for tenants, but we're going to focus on landlords today because obviously the majority of you are landlords here. Now, the reason why landlords come to us is they want initially advice on tenancy agreements or that they've got from their agents. But leaders, we are happy and we've seen their tenancy agreements, they have it all covered. So on that point and that, we don't really need to expand on it. The one thing that we do make sure is that there is a break clause if you need it in order to get the tenants out if there is a problem, which again, like I said, the leaders' tenancy agreements cover that already. The main points that we have are rent arrears. Tenants, they usually pay for a couple of months and then there's a problem, either they are not, they're not getting paid for their employee, they've lost their jobs, or alternatively they just think, actually, you know what, I'm just not going to pay. And in that case, you then become out of pocket because you have to still pay the mortgage, you're not getting the rent back from them, and therefore you then need to basically go to leaders and say, we're not getting the rent, and therefore what can we do? Leaders then pass you on over to us, in which case then we can say, okay, if you're 2 months in arrears, we can start the process. And the way it works out in the process with the law is that the tenant must be 2 months or more in arrears in order to be able to start that motion involving them to get them out if we need to. Sometimes it's just that little bit of a nudge in order to be able to say, actually, you're 2 months in arrears, and then they either say, oh, sorry, my direct debit didn't go through, or for other reasons, in which case that little nudge will make them pay that 2 months in arrears, and you're back in square one and you're all right. In the event that they don't pay the rent, and they are still 2 months in arrears, we then are able to assist insofar as issuing possession proceedings to get them out of the property. Now, there are bad things and good things in relation to it, because if a tenant knows the system, then what they do is they wait until the 2 months are in arrears, you've served the notice, you start the proceedings, and then as soon as the proceeding date is coming up, they then pay the rent, and then you're back at square one. Whilst you have your rent, you can't get possession of the property. You could still go to court on the basis that whilst they paid the rent, they still keep on paying it late, in which case you're like, they're not a good tenant, I want them out. But effectively, if they do know the system, then that is the difficult. That's why all the checks are done when you start up with the tenancy with the leaders. There are discretionary grounds which the court can grant. So, for example, if they are persistent in arrears, late in arrears, then the judge could say, well, actually, for the last 6 to 7 months, they're continuously being late, and it seems that they do know the system, and therefore they take sympathy with the landlords and they give you possession. But in the event that they are 2 months in arrears on the date of the hearing, then the judge must give you possession, and therefore any excuse that the tenant gives, oh, this happened, then the judge doesn't have discretion on doing that. Tenants could raise lots of issues such as, oh, well, the landlord didn't do this, or he did this, and they didn't fix this. And if those things are raised, then the court process could be prolonged. So that's why it's very important to make sure if there is any issues in the property, so for example, if they call you to say, my dishwasher's broken, can you come and fix it? You don't ignore that, because that could be a reason why they prolong the matter, in which case it's going to take a lot longer to get the tenants out of the property. With the other one is after tenancies come to an end. So if it's 12-month tenancy, and on the 10th month you're deciding, I'm not going to rent this property out to the tenant, I'm probably going to get some more money out from someone else, and therefore I want them out. There's a notice which we can serve, which gives them 2 months or more notice to say, at the end of the tenancy agreement, we're not going to renew it. Tenants at that point sometimes, if you've not got a good relationship or they have issues, they can start avoiding to pay rent. But hopefully most of them you don't, and they continue to pay, and they just want to be out as well. Some of them are council tenants, and the council will say, no, unfortunately, you must stay in the property until the landlord has gone through the eviction process, which is obviously not great for the landlord, but at least you know that you, especially if you're getting your rent direct from the council, you will be paid during that period of time. And therefore, it's just about going through the motions of getting the court eviction date and then proceeding on that bit, which I'll talk a bit later on about. The other thing, the reasons why landlords come to us is that the notice is expired, but they don't want to go through the process of going to court because it's not a very nice thing. Whilst I know we do it because we enjoy what we do. I know some of you are thinking, why? I know. But they want that reassurance, and they want just that little bit of a nudge to think, do I really have to go through the whole process to get them out? Or is it just a little nudge that they need to be able to say, you need to go on your way? So sometimes landlords say to me, Amelia, the notice is expired, I don't really want to go through the court process, what can I do? So I say to them, right, well, we can go through the court process, but I think if the tenant's on the fence and they don't need a court order because they need to be rehoused by the council, well, I say it might be that a solicitor's letter, give them a nudge in the right direction, will make them move. And a lot of times it does. So it's a much more cost-effective way for the landlord to deal with it that way, as opposed to going through the whole motions of a 3 months process. And again, I'll talk about that process a little bit later. The other thing the landlords want, they want reassurance. They want to know someone else is in control and are on top of the matter, so that they don't have to worry about it. That is why that you get, agents, leaders to do getting your tenants in or managing your properties, because you're there to be able to have your portfolio and deal with what it is and be able to make your money. But you want the reassurance of someone else to say, you know what, after this point in time, you will get your property back and you will be able to recover your rent on these different bases. So it's for those reasons why, landlords come to us. Now, I'm going to give a couple of examples of cases that have happened in the past, which is sometimes maybe you'll be able to relate to it and think, oh, yep, that happened to me, or, oh, this is what it is. So then you can kind of avoid those, or just have reassurance that, this won't happen to me because I've got this and that in place. So, for example, I've got some landlords who come to me and say, here's a tenancy agreement that I've got. We let the tenants out, we gave them a 12-month tenancy with a potential to extend. And we said to them that we would do X, Y, and Z before they moved into the property, and in the first few months we would paint the walls, or we would change the washing machine or things like that. Then what happens is the tenant relied upon this information, but nothing was noted down in writing, because they did everything themselves. They wanted to bypass the estate agents without having to do a proper tenancy agreement, and that's why they came to me, because they didn't have anything in writing, and the tenant was then saying, well, I'm not going to give you your rent, and then they're in trouble, because now they're 2 months in arrears. I've served the notice for them, but again, that means that the next step is for me to issue proceedings. She doesn't want me to issue proceedings because it's going to cost her more. So not only is she 2 months in arrears, she's going to have to pay for legal fees in order to get her tenant out to the position that she wants to get her property back, because she's still liable for the mortgage. She still has to pay all the outgoings and things like that. And she's like, Amelia, what am I going to do? So we write to the tenant and we say, right, this is the situation. And then it comes out, more information comes out. Well, actually, the landlord said that before I'd moved in, you were going to do X, Y, and Z. And I'm like, well, did you say this? And they said, well, we would do this. We would paint the kitchen, but not the corridors. And the tenant writes back and says, well, no, the landlord said that they would paint all the rooms, would replace the washing machine and the dishwasher, and effectively we're stuck because it's the landlord's word against the tenant with nothing really in writing between the parties. So it's, who are you going to believe? Well, obviously I believe my client because that's my instructions. But when you go to court, the judge makes that decision. It's who are they going to believe in relation to in the witness box. So effectively, the tenant asks for all this money to be reimbursed to them, to say, I want £4,500 worth of, I've got £4,500 worth of receipts for good that I've done to the property. So I've laid new flooring, I've done all of this painting, and the landlord has no evidence to show me that they've agreed this, or in fact said that they could do it, because I can't do anything other than what they've given me. So in which case we're stuck. Landlord wants them out at a cost-effective way. Notice isn't going to expire for a couple more months, so she's like, Amelia, I need this tenant out. Okay, well we can't legally do it for another couple of months because the notice hasn't expired, but at the same time the tenant's saying to me, well I'll leave if she gives me £4,500. What am I going to do? Am I going to pay £4,500 to this tenant when they owe me 2 months rent and all of this? No. You want your property back, but effectively you're not going to be held ransom to a tenant. So in which case you've got to have all these arguments, in which case, or backings up, or try and find scraps of papers that you've got that you can show that this is actually what was agreed, and then come to some sort of balance. At the moment we're still trying to sort it out. Hopefully we'll be able to get a good deal for the landlord, but effectively that's why it's so important to make sure things like the inventory and everything like that is carefully drawn out, so you both know where you stand from the beginning and until the end of the tenancy. The other one, another problem we have is when you have a tenant and they go AWOL. So they're not paying rent and you don't know, well, you can't get in contact with them. So what can you do? Can you just take possession of your property? Well, that's a risk for the landlord. We would say to you, well, you can if you want, but if they come back and you didn't know they'd gone on an extended holiday, how do you know? Because they've not given the keys back, they've not given back possession of the property, so how do you know that they've definitely gone? So we say to the landlords, right, well, you have to go, the option is you take the risk and you take the property back, or alternatively you go through the process. In which case we'd have to serve the appropriate notices and issue court proceedings and go to a judge and say the rent's 2 months or more in arrears, can we have possession? In which case you've then got a possession order which will then prevent the tenant from saying actually you didn't do it the right way. Because effectively you don't want to expose yourself to anything that would cause the tenant to come back to you and say you've illegally evicted me from the property. Which brings me on to my next case where we serve notice to the tenant, he kicks up a fuss, the landlord says to me, oh, the tenant gave me the keys back, and he's got the keys, but the tenant says to me, he forced me to give the keys, and when you look at my client, big butch guy, shaved head and things like that, it doesn't look good if I go to court with him, and the tenant's a little man, and insofar as he says, you mean you believe him, the judge is probably going to be in the tenant's favour, to say, yes, the landlord did bully him to give him the keys back. In which case, the tenant has the rights of a Protection from Eviction Act, can issue an injunction against you to get back into the property. And that's the worst thing. Once you've got possession, you want to rent it out to someone who can pay, or is going to be a good tenant, rather than having someone that's going to, mess you around or anything like that. In which case I said to the landlord, the risk is yours, but I would suggest you let him back into the property, do the proper notices, give him the 2 months notice, and get him out the right way. In which case he agreed, the tenant went back into the property, stayed there for the last 2 months, continued to pay the rent, and then at the end he gave his keys and said thank you very much, that was it. So the landlord was protected, because what you don't want is to be exposed, because it's a much more costly way to deal with it. Now, the process. Now, I'm not going to go and bore you with the law and the legislation and things like that. I'm just going to talk to you about the practical methods of how it all works and how it all comes together. Because that's not something, you don't really want to know about what the Housing Act says and things like that. What I'm doing is, insofar as there's a stage process, in which case some of you will be aware of it because you may have gone through it yourself, or you may have passed out to others, insofar as you serve the notice, and the two main ones that we talk about is the rent arrears and the end of the tenancy agreement. There are other grounds which you can rely upon, such as breaching of the tenancy of nuisance, or not repairing aspects of it, or not informing the landlord. But all of those sort of grounds are all discretionary. So the judge doesn't have to give you possession of your property based on those grounds. The main ones that the judge must give you possession, if they are still, say, 2 months in arrears, or the tenancy has come to an end, they are the only two mandatory grounds on which the judge must give you possession of your property. Now, for example, this is based on a rent arrears diagram. So we serve the notice, 2 weeks the tenant has to pay the rent arrears, 2 months or more. So if they pay £5 less than 2 months, you can't go on to the next step, which is issuing possession proceedings. Which is why I said in the tenants, if they know the system, they'll know they can just pay a little bit to get out of it. But effectively, if they're 2 months or more in arrears, you can go on to the next step, which is then getting the court process. So there's claim forms, you attach all your documents and things like that, making sure it's all correct, and you issue it at court proceedings. Court then gives you a date, in which case the parties must attend. Now this is the main standard possession proceeding route. Now, practicality, it can take between 4 to 6 months. Now it does depend on the different boroughs or in the council, wherever the council is. Kingston are relatively quite good, they get it quickly done, but if sometimes in Croydon the court is not so great, so it takes a little bit longer. But we try and give an estimate 4 to 6 months to get this sorted. The court proceedings are issued, you get a hearing date, we then have to do witness statements because you have to show that you've done all the notices correctly, you've served them all properly, and they all accord and correspond with the right date to the tenancy agreement. Because once you've got one of those wrong, that's it, it all fails. In which case, you may as well start again. Once you've got the hearing date, you turn up and you have to give evidence. So for example, if it's a rent arrear case, we usually get one of the property managers to do a statement to say, yes, on the date of the hearing, this person is 4 months in arrears now. And then at that hearing, if the tenant is still 2 months or more in arrears, which we can confirm it is, the judge will give you possession within 14 days and a judgment for your arrears. So you then have a court order which is valid for 6 years to enforce against that tenant to recover that money. Whether or not it's cost effective to recover that money is something later that you can consider, but you still have that judgment for that money that you have effectively lost. Then what happens is, once you've got a possession order, you've got a date, and it's D-Day. So you wait until that day comes, and they've got until midnight to leave, and the next day we'll call up the agent and say, have they left? And they'll say, nope, not leaving. Because either they can't, or they've got their new tenancy agreement doesn't start for another couple of days. In which case we fall on to the next stage, which is eviction. Now the eviction process is applying for a bailiff. Now bailiffs are scary things, but sometimes, as other people would have seen, they're not big butch guys. Sometimes they're tiny little people like me going around evicting these people, but that is just the process of getting them out of the property. Majority, if not all of the tenants will vacate before the actual appointment of when the bailiff comes. But if they don't, the bailiff has the authority from the court to evict them. In which case, by that date, you will have your property back. And then you'll have to go through the motions of dealing with the deposit and things like that. Now, with regards to notice of I'm coming to the end of my tenancy agreement, I've given my section 21, i.e. you no longer want them in the property, there's two routes that you can go by. You can go by this longer route, because you're also owed rent, or you can do it the accelerated route. Now what we try and do is we try and advise you on the best way for you. It's not the best way for we have to look at each case by case. Sometimes if there's £20,000 in arrears, you just don't know, then it's probably better to go the slower route because you'll get a judgment for that arrears. If it's 1 or 2 months, you kind of think, I'm going to cut my losses, I'd rather get possession of my property sooner, rather than try and think about the rent and get a judgment on that basis, in which case we say your primary concern is getting your property back, and then later we can talk about county court proceedings for getting the rent back or anything like that. Because remember, you've still got the deposit service who can help you recover some of the monies through the arbitration process. So And the accelerated route avoids the necessity for a hearing, because hearings are daunting. So if you don't want to go, sometimes it's like, actually, what I want to do is I just want a date for possession, and that's it. I don't want to go to court. I don't want to say I'm owed this much money or anything like that. I don't want to see the tenant again. I just want to get possession of my property. In which case, once the notice is expired, the proceedings have been issued, and then you get a date for the tenant to be able to file a defence. If they haven't filed a defence, you ask for possession. Usually possession comes within 14 to 21 days, and then you've got your D-Day again. You've got the date. If they don't leave, you have to go through the bailiff appointment again. But it's a much shorter route, and it takes between 3 to 4 months, again, depending on the court. So it is very much kind of weighing up what is best for you and the tenant, because you know your tenants. So you know what is the best way. Are they going to leave? Are they not? So we try to make sure we assess the right approach for your particular circumstances, as well as the tenant, to make sure that we get it right. Now, costs. I'm sure all of you worry about costs involved in dealing with this. It's known solicitors are expensive. But, for example, with possession proceedings and landlord and tenant work, what we do is we do it fixed fees, because then you know what you're in for. So, for example, notices we do, they say £85 plus VAT, and we do possession proceedings as a fixed fee. So you definitely have to pay the court fee to get the it all moving, and it's £175. And then we've got possession, like fixed fees for £750 plus VAT. So it's all in stages. So you do notices, proceedings, eviction. So you've got it all, so you know what you're in for. Now, if you go through the shorter route, accelerated, the court will award you about approximately £250 because you've taken the shorter route, because you're doing it without a hearing. The judge isn't listening to your arguments for why you've had to incur these costs. With the longer route, the standard possession proceedings, you have a hearing, in which case you can advocate to the judge and say, well, actually, I've had to do X, Y, and Z, and therefore can I have my costs? Costs are not guaranteed. They are discretionary and up to the judge. But if you put a good argument forward, you'll predominantly get a majority of your costs. Because you say, I've been put out because of this tenant. So why should I have to put up with all the fees when, you know, they're just staying in my property rent-free, and I've had to deal with all the stress? No, I want my cost, and the judge will give them to you. Now, on the other side is, why do tenants come to us?
Before you finish that, may I just ask, at what right do bailiffs have to enter the property? Because there's quite a misunderstanding along that.
Yeah, with the bailiffs, when you've got in a court, because you've got to go to court order, so when you start the process, you apply for a bailiff appointment, and the bailiff then gives you a date in which they can arrive, they turn up to the property. The bailiff has the court sanction in order to evict the individuals. So as long as you've gone through that process, it's okay. If you don't, then the tenant has effectively a claim against you for protection from eviction, because you haven't gone through the whole process.
Yes, I'm rather more concerned when the tenant doesn't open the door, for instance.
The thing is, when you fill in the form and deal with all the applying for the bailiff, there is a form attached to it which says, are we going to have problems with this tenant? For example, I had one where the tenant had tried to avoid and delay everything, and I knew there was going to be issues. So you call the local police, and they can assist with the bailiff to attend at the property. Because that's what you know what your tenants are like. And so far as if they've caused a massive fuss for the whole of the process, you know they're not going to go out, you know, just swinging, you know, smiling and saying, okay, thanks very much. They're not. They're going to put up a fight, in which case you get the police involved, and they have the right to evict them.
Do they have the right to go through the door?
Yes, they've got the right. They've got the court sanction and the police to go through the property, so as long as you've gone through the process. So they can go in, and that's why you always change the lock, get a locksmith to change everything, but they have the authority to go through, as long as you've gone through the correct process. So on the other side, tenants coming in, why do they want to speak to us? Now obviously what they want is they've got a tenancy agreement and they don't understand it, because there's lots of points in it, and some tenancy agreements are very detailed. So they just want an explanation of what these clauses mean. So we give them some advice on that. We do, like I said before, we predominantly act for landlords, but there is the odd tenant that comes to us and says, can you help us? And obviously, you know, we can't turn away business and such, so we do help them in that respect. They want to know, the other thing they come to us is the landlord, what the landlord is doing, are they doing it correctly? So if their landlord's written a letter saying, this is what I'm going to do, X, Y, and Z, are they doing it correctly? So we can say to them, well, this is the law, this is what they're supposed to do. So if for example, they write to you and say, I'm coming to take possession of my property within 7 days, no, you can't do that. So we'd say to them, no, you can stay in the property. And the other one is they come with us with notices. Is this a valid notice? In which case we assess it, look at it, see if they're right. If it's not valid, you have no grounds on which to evict them, which is why it's so important to get these things right. The other main thing that was a problem in the past, but not as much now, is deposits. Landlords are effectively the big bad wolves. Now, because of the tenancy deposit scheme, it makes it harder for the landlord to get the deposit back when the tenant has made lots of mess and damage to the property. But what happened in the past was landlords would just say, well, I fancy a new kitchen, so I'll deduct that from the deposit and things like that. Can't do that now, because you've got to have that inventory to show what it was like at the beginning and what it was at the end. And therefore, you need to make sure that those are in order to be able to ensure that you can try, if they have damaged it, to recoup as much of the deposit. But alternatively, for the tenant's point of view, to make sure that they can get all their deposit back. Because it's a lot of money to lose out just because they've not done things properly. So nowadays we don't have so many issues with that because of the deposit scheme, and we usually refer them to just deal with the arbitrator rather than getting solicitors involved. It's just not worth it. And which brings me on to this one, getting things right the first time. We've seen a lot of things go wrong because notices are wrong. Whether their dates are wrong, whether they've not got the right documentation attached to the claim forms, the court will not grant you possession of your property if things are not in the right order. You have to make sure these are correct. I've got a case at the moment where the tenant she was the landlord and she did everything herself, days for service and this and that. And she said to me, no, the judge said to me it was fine. I said, okay, that's fine, you go ahead with it. I'm telling you now, you won't get possession. And what happened? She didn't get possession because it went before another judge who said, no, this notice isn't valid. You've got to start the whole process again. So not only does she have to pay the court fee again and everything else, she had to get me to do it all with her, to do it for her, when I told her right at the beginning, it's not right. So why some people will do it. You try and save money in the first place to try and avoid it, but what will happen is, later down the line, you'll get stuck and you'll get stung because you'll have to pay double. Now, that's why some of the tenancy agreements that I've seen, they have clauses, they don't have the relevant clauses that you need to protect the landlords, but they think, you know what, no, I'm going to go to W.H. Smith, I'm going to buy the pack of doing your own draft tenancy. Fair enough, it might be good for once or twice, but when you then get stung by a tenant who knows the system, who knows how to work it, that's when you think, why have I not done it properly? That is when the problems arise, because then you can't enforce the clauses that you would want to enforce, such as inspecting of your property at a quarterly rate. Some tenancy agreements don't have that. Or the fact that they don't allow you to, like, smoking, not that you don't want smoking in the property, or pets, or anything like that. There's some basic clauses in there, break clauses, which protect you as well as sometimes, effectively you don't want to rent out your property for all that time. It protects you, so it's best getting these things right. Because once you've got it wrong, that's when it hurts. And I have some landlords who say, for 20 years I've had no problems, and then I have one tenant who is awful and puts you absolutely grey hair. Because you're so worried about it, because they've not done anything, you're out of pocket, and all of these sort of things. So in those examples, it's much better to get it right the first time, to avoid having to see solicitors all the time. And as a result of that, that's why we do advice, because that's why we have the relationship with leaders. We're here to help. So if you've got questions and things, we're here to help. You don't have to instruct us to deal with it. It's more about us making sure you've got the right process or the right advice to be able to move to the next steps. We do fixed prices in order so you know exactly what it is, you need to budget and things like that. And we try and do the notices on the same day. We try and keep up to date on what's new, and that's why on our website we have blogs, anything that's interesting for landlords to know about. See, for the new deposit scheme and things like that, it's we try to keep you up to date. So in those sort of things, that's why it's important to know what's current news. And therefore, get it right the right way so you don't have to get stuck. And that's it for me.
May I ask a quick question, please?
Oh, sure.
When the tenancy ends, I
Yes.
guess you have, and they want to stay, you have a choice of doing a new tenancy or
Yes.
becoming periodic.
Correct.
What is best course of action?
It depends on your situation. So, for example, having a new fixed-term tenancy means that they're bound by another 12 months, which is good. But in the event that you might think, actually, I might want to sell in the next 6 or the next 3. It's kind of when you're unsure, it's good to do a periodic tenancy. It is case-by-case fact basis, but you have to assess on your situation what you want and what you want to get out, because you never know what your situation is, in which case you may want to go back into the property, and therefore you do have to look at it on a case-by-case basis. But if there's any other questions, then
But if you go into periodic, do you lose some eviction rights, technically?
no,
You have the
because
same
you have to
rights.
do the notices effectively in accordance with the tenancy agreement.
Okay, so both type of scenario give you the same rights.
Yeah, you just have to do the different notices.
Okay, thank
Okay.
you.
There is